Okay, so good morning, everyone. Thanks for being here today. My name is Pilar Colomés, and I'm chairing this panel. Before I introduce our excellent panelists, I'd like to talk a little bit about me and why we decided to choose this topic for this panel. My name is Pilar Colomés. I'm a counsel at Eversheds, Sutherland in Spain. I'm a U.S. attorney, and I'm also an attorney in Spain, and I have international experience as an arbitrator and as a counsel. The reason why we decided to choose this topic is because, as many people may know, there's been a lot of recent developments on climate change and environmental, social, and governance standards made by the international community. And one of the topics that we believe has touch upon a lot on international disputes, especially those resolved by arbitration, is climate change and energy transition and environmental standards. So this is mainly the reason why I've selected this incredible, experienced, and knowledgeable group of practitioners in the field, which will help us understand this topic better and have an interesting discussion on this. I'm going to introduce the panelists very briefly because they have an outstanding experience, so it's really hard to encapsulate everything in just 1 minute, but I'll start on my right-hand side by Ximena Fuentes. She's former Undersecretary of Foreign Affairs in Chile, and she was agent for the Chilean government in the dispute over the status and the use of the Silala waters, which was an ICJ, a very relevant ICJ dispute. So we welcome her. Obviously, she has way more experience than what I just mentioned, but we welcome her to this panel. On my further down on my right-hand side, we have Pilar Perales. She's a professor of law at Carlos III University. She teaches international commercial arbitration and commercial law. She's also chair of the CISG Advisory Council. She's an arbitrator, and she also chairs and directs the Spanish arbitration moot court, also led by the Carlos III University. We now have Lisa Sachs, and she is director of the Colombia University Center on Sustainable Investment. She teaches obviously at Columbia Law School. She does a lot of research on these topics, and I follow her very closely, and I know she's excellent and she knows a lot about this topic, so I'm sure she's going to impress us. Then I have here Ashlesha Srviastava. Sorry, I don't know if I'm pronouncing it properly. She is Deputy Counsel at the International Court of Arbitration and the International Chamber of Commerce here in New York. She is also a U.S. attorney, and she's also an attorney in India. She obviously comes originally from India, and she has an LLM at Columbia University, and she's also practiced in the past as practitioner and as an arbitrator. And last but not least, because we are missing someone, I don't know where the other panelist is, but obviously last but not least, we have José Antonio Rivas. He's originally from Colombia, but he is the founding partner of Xtrategy LLP in DC. He has a lot of experience in investment and commercial arbitration matters and public international law, and he also acts as an arbitrator, in obviously certain ad hoc disputes. We're missing Santiago Solines, but I hope he comes at some point. We will be happy to join him during our conversation, but I think we should get started. And I've mentioned a little bit in the beginning, a little bit overview of what's going on in the international community in this field of environmental law and climate change. But I want to hear a little bit more from the institutional perspective, and that's why I decided to invite Ashlesha to give us a general overview of how do you see that these recent developments or regulations in climate change are impacting international arbitration, and how do you see this impact has been from the institutional perspective? If you can enlighten us. Sorry.
Good morning, everyone. It's a pleasure to be here and share the stage with my very esteemed and knowledgeable co-panelists. And thank you, Pilar, for that introduction and for setting the stage for our discussion on a very interesting and timely topic. My name is Ashlesha Srviastava. I work as a deputy counsel with the ICC Court of International Arbitration here in New York as part of the North America case management team. For those in the audience that are not familiar with the ICC is the International Chamber of Commerce. It is a world business organization and an institutional representative of over 45 million companies in the private sector. In more than 130 countries worldwide. The ICC provides several essential services, and dispute resolution is one of them through the ICC International Court of Arbitration, which is now widely regarded as the world's leading arbitral institute in helping resolve international commercial as well as more recently investment disputes. With that being said, about the dispute resolution leg of the ICC also has a broader mission to promote open international trade, responsible business conduct, as well as promote global policy approaches. And as part of that broader mission, the ICC has had a long history of promoting climate change justice. It's been involved in the UN Framework Convention of Climate Change, the UNFCCC, negotiations for over 3 decades, and has represented the private sector at every conference of the parties since 1992. The ICC was actively involved during the famous COP21, which led to the signing of the Paris Agreement, and it played a key role in advocating for the delivery of the Paris Agreement. After the Paris conference, the ICC also published a book titled Dispute Resolution and Climate Change, the Paris Agreement and Beyond. This book contains a collection of papers from the COP21 that discuss how climate change and the required responses internationally will cause disruption and drive new disputes. More recently, the ICC has created a task force on arbitration of climate change-related disputes and released its report and findings in a report titled Resolving Climate Change Disputes Through Arbitration and Alternate Dispute Resolution. This task force comprised of over 100 members across various industries and sectors, including business representatives, lawyers, NGO representatives, arbitrators, arbitral institutions. The idea being behind the task force and the report itself to examine what climate change disputes look like, whether arbitration can be used as an effective tool to resolve these disputes, whether the existing arbitration regime is well suited to resolve these disputes, and how it can adapt in future to meet the specific features of climate change disputes. With that background, I'll describe a little briefly what climate change disputes are. Following the Paris Agreement in 2018, the United Nations Intergovernmental Panel on Climate Change, the IPCC, warned that significant changes would be required to avoid the worst effects of climate change. These significant changes will require rapid and far-reaching transitions of land, energy, industrial, and infrastructure systems. These required transitions to our energy, land, urban, and infrastructure systems will necessarily give rise to new investment regimes, new contracts, and these contracts and investments will inevitably lead to contractual disputes and other legal disputes. With that being said, there are 3 broad categories of contracts that could give rise to climate change disputes. The first category involves contracts that are concluded to meet the specific climate change goals or commitments. This means implementing transition systems, mitigation, or adaptation in line with the Paris Agreement commitments. An example here would be a renewable energy project for a wind farm being built with the aim of achieving the emissions reduction targets under the Paris Agreement. Now, what happens here when the contractor completes building the wind farm and demands payment, but the owner refuses to make the payment, alleging that the wind farm, the output does not conform with the regulatory requirements as laid down by the public authorities for a governmental approval. So that could be one example of a case of a contract which was concluded specifically to meet climate change goals. The second kind of disputes arise under general commercial contracts in the construction and engineering sector or the energy sector that don't have a specific climate-related purpose, but where a dispute involves or could give rise to an environmental claim. A good example here would be a construction contract for the construction of a deep-water seaport. And when the contractor begins the construction of the project, the contractor encounters increased salinity in the freshwater sources, which inevitably lead to a longer time frame for the completion of the project than anticipated, and then that eventually results in additional costs. So the claim here would be whether the contractor is entitled to an extension of time claim, or can the contractor claim additional costs from the owner. But the issue here would be if there is a finding that the increased salinity in the freshwater sources was a result or attributable to rising sea levels as a result of climate change, then how do we allocate the risk here, and who shares the burden of the costs? The last kind of contractual disputes that we anticipate seeing are under submission agreements or submission contracts after a contract has arisen to help allow impacted populations or groups to resolve their disputes in a specified forum. An example here would be a foreign investor constructing an infrastructure project in the coastal area of a state where the construction and the building project has adversely impacted the small local businesses, including the fishermen or the local farmers. And this group of impacted population then sues the foreign investor in the host state, alleging violations of constitutional rights and environmental claims, etc. Here, one way to resolve this dispute would be if the impacted population and the investor were to sign an agreement to resolve their disputes before a specialized forum, for example, arbitration or another expert tribunal to look into the disputes. In addition to these contractual disputes that I have described, climate change-related disputes can also result pursuant to investor-state treaties and also as a violation of domestic laws and regulations that are intended to address climate change, etc. These cases will typically go before the state's national local court system. So there is room for litigation, and there is litigation of cases for these specific type of climate-related disputes. However, as we are all aware, climate change is one of the biggest imperatives of our times, and the global response to climate change will continue to bring more climate action initiatives, more green investments, and more commercial contracts that are intended to comply with state commitments under the Paris Agreement. There will also be an increase in the regulation of industries and activities having environmental and climate change impacts. Therefore, it's a global problem that's not restricted only geographically, but also impacts dispute resolution more globally, and we need to have appropriate dispute resolution mechanisms to address these kind of disputes. From what we are seeing right now, commercial arbitration in particular is very well and uniquely suited to address these kind of disputes. The inherent internationalism aspect offered by commercial arbitration, which transcends into the inherent flexibility that parties have in choosing the arbitrators or experts who have that specific required scientific knowledge or technical knowledge, is one of the aspects that makes international arbitration very attractive. Another few advantages that international commercial arbitration specifically offers is that the parties have inherent flexibility in also choosing a neutral forum where these disputes can be resolved. And of course, the parties, depending on whether it's an institutional arbitration, most leading institutional arbitrations provide a forum also for addressing emergency relief through the use of emergency arbitrators. So there is scope for expedient proceedings instead of going to the local court system. So that is another advantage that international arbitration offers. And I think the most important part also is the seamless award enforcement possibility responsibilities, just given the overwhelming majority of states that have ratified the New York Convention on the Recognition and Enforcement of Foreign Awards.
Because I think this is probably something that Pilar is going to address.
Moving on. No, I just wanted to give a very brief overview on what makes international arbitration well suited for these kind of disputes, and I know I will leave it to Pilar to discuss this in more detail. No, of course, to overlap. I know we discussed this before.
Okay.
But I do want to just sum this up by saying that we are seeing an increase in the kind of disputes that involve environmental claims or climate change aspects, and this will continue to increase. I also want to just reflect very quickly on the caseload statistics that we have at the ICC, which shows that the industries that will see the most impact in terms of the regulation that will change or transition systems will be industries such as the construction and engineering sector, the energy sector, transport sectors. And these industries typically already use international arbitration clauses in their contracts for dispute resolution, and we can expect to see an increase in these types of cases in these industries. In fact, just looking at the ICC's caseloads in the last 24 months, out of the total case registered by the ICC Court of Arbitration, close to 22% are from the construction and engineering sector. The next one is the energy sector, close to 18%, followed by transport and telecommunications and so on. So we can continue to see that these are the sectors from where most of the cases are going to arise, and I think while we don't see specific climate change related arbitrations, they are not called that, but we can expect to see that these are the kind of disputes that will continue to be on the rise. And at the moment, international arbitration is well suited to resolve these disputes, but as we see more and more cases, because this is an evolving space, I think the international arbitration community also needs to consider on the whole how to adapt and innovate as the nature of disputes that we see change, whether it's arbitral institutions that need to adapt more specific procedural rules, or if it's practitioners or arbitrators who possess the necessary skills to come out and also promote resolving disputes through arbitration. So that's, in conclusion, this is an evolving space that we need to watch out for and sort of just join hands and innovate to the best of our ability so that international arbitration stays relevant in the space. And with that,
the next question I
yes,
will ask,
of course.
It's very quickly,
yes.
Is the ICC going to develop a new set of rules specifically prepared to address climate change disputes? Is the ICC working on this, or because I know rules such as like the PCA rules, like having developing a specific set of rules for that, is it something that it's on the workflow? Or
I think it's definitely a point for consideration that the task force is well aware of and highlighted very initially, even when this report was formed, that as time goes on, this is an important aspect that the ICC and all other institutions will have to cater to. We don't have any specific mechanics yet, but then again, this is a work in progress, and we'll see how this evolves.
Okay. She knows how to get out of She's been trained for that. Okay, so now
thank you so much.
Yeah, of course. Obviously, I didn't mention that, but everybody feel free, please, to just interrupt or ask any questions. This is more. My intention is that this is more like a conversation than like a lecture. So please feel free to jump in. Ximena, as Ashlesha has been mentioned, a lot of has touched upon a lot of issues related to arbitration in the climate change being closely tied to technicalities and to specific knowledge on technical issues. I completely agree. For example, in ESG industry or the ESG disputes, I believe the part on environmental disputes is way more related, or it has a much more complex technical nature than, for example, social and governance disputes, right? Social and governance disputes are generally related to human rights, which is a purely legal construction, based on purely legal construction, whereas environmental disputes are really, really closely tied to specific knowledge on technical issues. So my question to you is, in your experience, because you've been part of, you've been an important representative in Chile for big climate change or environmental disputes, is what role science plays in this type of disputes, and what specific skills does an arbitrator or a counsel in this type of dispute requires?
Okay, well, thank you very much, Pilar, and good morning, everybody. Yes, I would like to speak about the role of science in climate change disputes. Given my experience as agent of the Republic of Chile in an ICJ case, the Silala case, which had to do with, the question there, the main question was the transboundary status of this river, which, by the way, is a very small river, but it is in the desert, therefore it was like gold. The other question, secondary question in that case, were the effects, if any, of a very small channelization that was done in the early 20th century in Bolivia. This case was between Chile and Bolivia, on the river. So one of the questions was, well, we have seen some effects, detrimental effects, in a wetland close to the river. So what is the cause of these effects, detrimental effects? Is it the channelization that is in place in the river, or is climate change? Because we have been experiencing, everybody has been experiencing droughts, more continuous droughts because of climate change. So I think that I can speak because I had to work with all these scientists, which were our experts. They were hired as our experts, and also the counterpart, Bolivia, also had their experts. And I think that there are a number of challenges in these climate change disputes. One is a question about the ability of arbitral tribunals, in fact, of tribunals in general, including counsel, to understand the science behind these disputes. This also means that you will have to take much care in the choice of arbitrators, the kind of skills they have. In the choice of counsel, arbitrators and counsel, they will require some knowledge to understand the scientific and technical basis of the dispute. And then the role of experts. If the dispute involves scientific and technical aspects, it is expected that the parties or the tribunal will appoint these experts. And the role of counsel will be, well, to advise your client well in terms of the experts that you will choose. And sometimes, as you are not a scientist and you get to be involved in some disputes of different, where you can touch different aspects. In my case, this was a river. So, well, I'm not a hydrologist, I am not a hydrogeologist, but I was the person in charge of deciding the hydrologist that we are going to hire. And the question, well, why him or her? Are you able to really assess the credentials of your experts, advisors? So it's interesting. You learn a lot, by the way, when you are in this kind of disputes. So now I think that maybe instead of law, I should study geology because it's really, really interesting. Well, now, what kind of disputes? Climate change disputes, as you have already said, are very ample, very broad. So it will be, I mean, any sort of dispute can be a climate change dispute today, as you said, contractual disputes, investor states disputes, everything can go into the label climate change dispute because it is any dispute arising out of the effects of climate change or any dispute arising out of climate change policies taken by the governments. So there is an ample spectrum of climate change related disputes. Now, with regard to the experts, which I think is the most interesting topic regarding science, first, we have to see that some tribunals, so we have already some cases in which tribunals have appointed experts, very renowned cases. So, for example, the South China Sea arbitration, there the tribunal appointed independent experts on a specific topic, which was the effects of the construction of artificial islands in the South China Sea, the effects on the coral reef environment. And there is a report, an important report that was very important in the arbitration. Now, there is another arbitration, the Ximena arbitration between India and Pakistan regarding the interpretation of the 1960 Indus Waters Treaty. And there it's interesting because you had 7 arbitrators. And among the 7, one was a scientist, which is a hydrologist, Howard Witter. That's why I hired then Howard Witter to work for us. And Howard Witter is very renowned hydrologist. And I spoke to him and he said, well, it was really challenging to work with lawyers. Because I'm not used to the language of lawyers. However, I already had some experience because I worked in the pulp mills case between Argentina and Uruguay. And I worked in the Capchicovo-Najimaros case. So I know lawyers. But it's different when you are sitting as an arbitrator. You have to decide. The Ximena arbitration, of course, was a very well-suited case for experts because it has to do with a number of works that India wanted to build, a diversion of water, etc. So really, you needed someone in the tribunal as an expert. Now, you can see that if you have only one and the other 6, of course, these experts will be God in terms of the science because everybody will rely on what he's saying. So we have to think about it because you need a tribunal that in a way there is certain equilibrium between the people that has to take a decision. Now, in the ICJ, we already know that there has been a certain development, I would say, a certain changes because the pulp mills case was criticized because there the experts, the scientists, were part of the team of counsel. Therefore, they were not available for cross-examination. That was criticized. Experts should always be available for cross-examination. So now, the practice before the International Court of Justice is that experts, are not counsel. And that is what happened in the Silala case. Experts were experts. So we had experts, DHI, the Danish Hydrological Institute, hired by Bolivia. In Chile, we hired Howard Witter. And Howard Witter told us, well, that we need someone else because I am a hydrologist and we need a hydrogeologist. So I recommend this. So we had 2 British experts. And then it was interesting because the people that know best the area, if this is territorially linked, are the scientists from the country involved in the case. So in that case, I decided that I had my British experts, but that they should work with the Chilean scientists. And that was very nice, because we went to the Catholic University, I remember, because they had already done some work in the Silala, and there we had a very good hydrologist and very good people, geologists. Also, we wanted to tell the story of the Silala since, I mean, millions of years ago when it was created. So it was a team of like 20 people working under the leadership of Howard Witter. And I think that this was a fantastic synergy between the two teams. So that was a great experience. And then the fact is that all the reports, when you have a case, it's very difficult to start doing science from the beginning, because all these studies take years. Yeah. So you will have to rely on information that is already available. Therefore, you will have to contact scientists around the world that have been studying a particular problem. And in this case, we had a lot of reports, previous reports, and then the experts said, well, but we need, what is missing here? So we need to do this and this and this in a year. In a year, because we were given a year by the ICJ to submit our memorial. A year, okay. So how much this costs? Mm-hmm. And of course, it's very expensive. Science is very expensive. In my case, well, it has to do with water. So the advice was, we have to make some more drilling, because we have drilling. Yes, we know the core and the geology and the behavior of these watercourse. But you need more. Okay, drilling in a year, very expensive. In a place, in the Altiplano, very difficult to get there with the machines. I mean, just to take the machines was an ordeal. And we did it. But we had the money, because this was a geopolitical problem with Bolivia. Now, if you're a private company, this can be a real problem for arbitration. And what kind of studies we have? We had topographical studies, hydrological data, hydrogeological studies, geophysical surveys, hydrochemical sampling, mapping, geomorphological studies, and this is the best, hydrogeological modeling. So the last thing I would like to say is about modeling. Because modeling, and normally you will have to rely on modeling for climate change disputes, is, apart from the thing that it is very expensive, it is a problem when you have two parties and two modelings, and because it would be very difficult for the tribunal to have a competition of models. So in this case, one of the things that we tried to avoid was a competition of modeling. So we said, well, DHI brings a model, because they sell models. That's their business. But I don't want to start doing from scratch a model. So we will have to only look and have a very close scrutiny of their model. And then I realized that modeling is not very reliable. Because in the end, it's a computer program, and scientists speak in this field as rubbish in, rubbish out. So it's very easy to have a rubbish in, rubbish out situation. But it's very difficult to spot it. So to spot it, first you need to buy the model, the program, the software. Then you need a computer to run it. which normally is a huge computer. So in Chile, for example, we said, who has a computer that can run this model? One university, one, because it was huge. Okay, now, how much time you need to run it and to spot where the rubbish in is? A year. Yes, but in a year I have to submit my memorial. You see, or my reply. So that was really, really challenging. And I think that here maybe we need a little bit of regulation. Mm-hmm. One is regulation about the ethics that is involved. I mean, experts. Scientists, we tend to think that they are better than us, the lawyers, and they are not, because they are human. Therefore, we need some regulations about the ethics, the ethical practice of scientists, and also we need some rules about how, I don't know if rules or certain directions for arbitral tribunals of how to deal with the science. For example, in the Silala case, when we were in the cross-examination, I could realize that among the 17 judges that we had, I said, well, I don't know if all of them can grasp what we are looking here when we were cross-examining DHI, for example. And only 2 of the judges asked questions. Mm-hmm. Judge Dunaway and Judge Tomka. And why? Uh-huh. Well, first, because the president of the tribunal, Judge Dunaway, well, because I was looking at the curriculum, and, well, it happens that she has a degree in biology. I didn't know. So biology and law, great to be involved in a scientific dispute. And Judge Tomka, well, he was the agent of Slovakia in the Gabčíkovo-Najimaros case. That's why he already had some training on this. But the rest, I look at the faces and I say, I don't know if they are getting the central points here. So, well, that's what I could share with you on this subject. Thank you very much.
Well, thank you, Ximena. It's very interesting. I think this is is a key point of environmental disputes. I always say that as an attorney, I'm getting involved in, and probably you all do, in a lot of commercial disputes and construction disputes, engineering disputes, infrastructure disputes, and I always say that the legal part is a very important one, but you win the case and you prevail on the case if you have a really good expert. And the same goes for investment arbitration. Yes. You really prevail the case if you have a very good damage expert supporting your case. And this I discuss a lot with the experts, probably you also do, but at the end of the day, when you're working on this type of cases which are very huge, I think the lawyer ends up studying a lot on the engineering part, and the engineer or the expert ends up learning a lot and studying a lot about the law. Yes. So it's kind of like a simultaneous, effort. And I think that also raises a very interesting question that I think you were kind of touching upon, which is the one that I asked Ashlesha, which is whether in the future or in the coming future, the arbitration rules will have to adapt to specific types of disputes, like environmental disputes or social and governance disputes, allowing, for example, I was in a panel a month ago and we were discussing that maybe the arbitration rules will have to adapt for social and governance disputes in terms of maybe allowing an amicus curiae participate, in a human rights disputes to present its case and advocate the case, not just as an amicus curiae, but as an interesting party to the proceeding. So it seems that the more types of different disputes that we are facing, throughout the evolvement of these new areas of law, the more specific and the more narrow and the more tailor-made the arbitration rules have to be. And that leads me to the next question, which I want to ask Pilar as an expert on commercial arbitration, which is, what do you think about arbitration as a tool to address this type of disputes? And do you see whether we are facing any challenges or any difficulties on this field to address this type of disputes?
Well, thank you very much, Pilar. I'm very happy to be here. So thank you for the invitation with this distinguished panel of the... Distinguished, thank you. Thank you with this distinguished panel of colleagues, and also, you know, it's the first time that I'm in a panel in which I share also the name with the another of the speakers. So we are the two Pilars here.
Yes.
You are the pillar of
this panel. But she's the pillar, but I'm supporting her.
Let's not rely too much on me in this word.
And also with Ximena, if I may, because also my eldest daughter name is Ximena as well. So I'm like at home almost. So in any event, let me begin with a phrase that I like a lot from Judge Staton as a dissenting vote in the famous case Juliana versus the United States of 2020. When the seas envelop our coastal cities, fires and droughts haunt our interiors, and storms ravage everything between, those remaining will ask, why did so many do so little? As you know, this has begun a movement here within the United States towards fighting against climate change. Mm-hmm. And here the question is what arbitration can do in order to fight climate change disputes. So I'm also grateful to Ashlesha because she put the framework for now the things that I would like also to comment here, to discuss here with you. And I would like to begin with the ESG factors. So we know it's environmental, social, and governance. Environmental is whether climate change is more into it. It is not the only factor. We have other factors within the E, the environmental factor, as well. But indeed, climate change is the one that is having a lot of attention in the last times due to the urgency of this problem. But climate change, from my perspective, cannot be understood also if we not take into account the other two letters, the social, because we have the human factor, the local communities involved, we have all the stakeholders that are, around corporations that also need to be paid attention here in this question of fighting climate change. The same with the governance. Unless we have a strong governance system within companies, the board of directors, and within the whole system of the corporation, I think it's going to be difficult from the private sector to fight against climate change. The same I would have to say if we consider the governance of arbitration institutions. Also, good governance of arbitration institutions, I think is key in terms of, for example, creating links. I think there is a way to go forward also in relation with commercial arbitration in this area, in terms of cooperation among arbitration institutions in order to fight against climate change. We have a very good example of cooperation among arbitration institutions when pandemic COVID-19 came in. And we had several examples on that. And I think in the area of climate change, arbitration institutions can really make an effort of cooperation and, bring new solutions and helping in this area. As I said, the good governance also goes into the ethics that was mentioned also before by Ximena, in the sense of choosing the right arbitrators with a specialization in this area. Maybe in the ICC form, you can add ESG matters as a way of expertise, because there's no one tackling this one. Of course, it's very difficult to find someone who is an expert on ESG matters, because ESG covers everything actually. But at least maybe you can find a way of also looking for experts in this area. Arbitration is very well suited, I think, for fighting against or as a tool for climate change disputes, because of some of the issues that were mentioned before by Ashlesha. But I would like to also to mention some more. And Pilar, I'm not paying attention to time.
Yes,
Let me know
I'll cut you off.
a couple of minutes
Thanks
before.
for allowing me, but that gives me more entitlement.
Sorry,
to do it.
I didn't pay attention to that.
No, thanks for it.
In any event, I was saying that from my perspective, arbitration is now, and I would like to say, is the last frontier in fighting against climate change, because we have seen a movement in the last years, in particular in the judicial system and in administrative bodies, dispute related to states or organs within a state. So we have very famous cases here in this area, and important cases too, that are now having an impact on what could be the future of private litigation, either within the judicial system or in arbitration. So that's, for example, we take a look with the Neubauer case in Germany, in the Constitutional Court in 2020, I believe. Now I'm missing the date, but in any event, it's a couple of years ago. You find now that it's moving into a third wave of litigation era in which private companies are being sued because of the effects of climate change in their activities. And these cases in the civil private litigation are relying precisely in the doctrines developed in these state cases against states led by NGOs. No? So the activism of NGOs is a very important question, how that would impact, as the case may be, in private litigation, or even in arbitration, although here the activism of NGOs is much more difficult to get because we need the arbitration agreement, we need the arbitration clause.
Exactly.
In any event, what we are seeing now is also the activism of NGOs taking positions as shareholders in corporations in order to bring claims against private companies. And that's a very, I think, interesting phenomenon that we are going to see in the future. Of course, we have also the possibility of having post-dispute clauses, as we have also have some experience with the Bangladesh factory situation. Yeah. And we will probably see more of this, we will see more of this in the future. So this, the flexibility of arbitration, the procedural rules that was commented here before, is one, I think, of the main advantages that we find in arbitration. But also creativity of arbitrators, I think, is a very important matter to consider here in terms of having a broad approach, a flexible approach towards disputes in this area, in order also to bring climate change scientific scenarios. There's no way to discuss, I think, after the IPCC reports, I think there's no way to discuss or to deny that climate change is a reality, although, of course, you can discuss within the effects of the different scenarios that the IPCC reports have been put forward. But still, you need here a lot of expertise and creativity by arbitrators in order to tackle all these issues of climate change. The same for something that was mentioned by you, Pilar, the intervention of third parties, stakeholders, local communities affected by, let's say, construction projects, whatever investment projects. Indeed, arbitration is also flexible in order to have either amicus curiae or third party. We've seen a lot of development on that due to UNCITRAL efforts in this area. And precisely UNCITRAL now is precisely this week, by the way, they are discussing whether to go into more rules related with climate change, not only in questions related to substantive matters, such as the legal implications of carbon credits. We will see a lot of arbitration coming on in the future about voluntary schemes of carbon credit. We have already have some arbitrations on that, but I think we will see more in the future because now we are in the process, we are seeing in the process of developing the voluntary carbon markets, and these new markets will need to have disputes settled by arbitration. And indeed, in the model contracts that we are seeing already, there's arbitration clause included. So, as I was saying, we will need probably to look further to the future and see what we can do in that area, cooperation among institutions, UNCITRAL and other interested bodies working on, as I said, not only carbon credits, but also in the area of arbitration. What would be the outcome? We do not know yet. It still is for the Commission in this, precisely in this week, to decide whether they will go further on working on developing rules on this area. So we will see, but indeed there are room for improvements. One of the issues that also was mentioned here was the whether we should have special arbitration rules to tackle climate change disputes. I'm not so sure that we need actually special arbitration rules. And we know we have the PCA, optional rules for environmental disputes. We know we have recently the 2019, the Hague Business Human Rights also rules for disputes in this area. But to be honest, I need to reflect more on this. Probably something that we can discuss here in the table, but I'm not so sure that we actually need more rules on that. We need probably some rules on arbitrability. I think that is probably, or it's going to be probably a problem because of the public policy involved in climate change disputes. Maybe I'm out of time now. No.
Yeah, I mean, I think you are pretty much, but everybody, I think, exceeded their time. So I'm not going to, I'm going to show some leniency towards you.
So let me then go to the last comment on this, and then maybe later on we can go further. When I was mentioning also about the creativity of arbitrators and flexibility of arbitration as an institution. And I think this is quite important in this area of climate change, and this will give rise to a consolidation and the raising of a customary climate change law, or if you prefer, lex mercatoria climatica, that I think that could be very useful for arbitrators because of the mass of hard laws and soft law rules in this area that we are beginning to see. Yes. Many of them that are being born or in the process of being created. Mm-hmm. So therefore, the job that arbitrators can do in order to give a mass, to give order to all this mass of rules, I think that could be a very important development in commercial arbitration.
Well, thank you, Pilar. I'd like to flag out a little bit of a few things that she mentioned. I forgot to mention that Pilar is an ex-member of the UNCITRAL board, delegation, the Spanish delegation on the UNCITRAL before the UNCITRAL. That's why she knows a lot about the agenda. And she's also a member of the sustainability board at Mapfre, which is like an insurance company, a Spanish insurance company. So that's why she she does her job very well, as you can see. But it's originally from Spain, but obviously it's very international. That's why she's so knowledgeable on issues on climate change, touching upon companies. And I think you mentioned a few things that I'm very interested in, which is first what you mentioned about you were talking a little bit about the lex mercatoria on climate change. Also, like you're hesitant whether the arbitration rules should be adapted specifically to climate change disputes. I tend to agree that they do not. They do not need to change, especially because of, as Ashlesha, what she's saying, that there's no such a thing as just like one environmental arbitration case, but I think there are like construction cases and infrastructure cases that touch upon climate change issues. So I think it's a little bit difficult to just create a set of specific rules only for environmental disputes, because there's no such a thing as just one environmental dispute. I think there are many international disputes that touch upon environmental issues. But I do think that arbitration rules need to adapt to allow for specific mechanisms, such as like the amicus curiae, to participate, for example, in the Glamis Gold case. There was an indigenous community involved, and the tribunal decided in favor of that community, but not taking into account their participation as an amicus curiae, but only on the basis of legal grounds. So in the end, the decision was favorable to that community, but it was not part of the reasoning why the tribunal decided on that favor. So I think rules need to be adapted, but I agree with you that there's no need for such a specific set of rules. And then the other thing I think is interesting, especially for corporations, which also leads me to the next question, which is, touching upon the creativity thing, that we've seen in the past a lot of soft law rules, but they are now evolving into hard law rules. For example, the directive on the European Union is issuing a directive on corporate sustainability for companies, and that's going to lead, in my view, a lot of disputes, because now corporations, not only states, have to comply with environmental standards, and that obviously is going to create a lot of concern within the corporations and their commercial partners, and that's something that I find very interesting. So we've been talking a lot about corporations, but now I'd like to talk about states, and we have Santiago, who I think joined a little bit late, but we're still going to allow him on the panel, so if you want to sit next to José Antonio, you are Santiago, no? Yeah. I'm like, oh, maybe so maybe you want to come closer and sit with us, because I think the camera is there, so probably you want to be shown. So Santiago's from Ecuador, and he has expertise on investment arbitration, and we were, focusing a little bit on commercial arbitration and corporations, and now I'd like to talk about states and how states have been, quotation marks, suffering, the need to adapt or the need to implement this environmental or climate change regulations, and how do they sort of balance the obligation to implement those changes, but also I guess like adapting to the energy transition, but also like respecting international treaties that they have in place.
Perfect. Well, thank you so much. I'm going to talk in Spanish, is fine? Because I prefer because I'm more comfortable.
Okay, but if
fine.
you already prepared,
Yeah.
but I mean, sorry, apologies for the part of the audience that doesn't understand.
Perfect. First I'm going to talk about Ecuador, and then I'm going to talk about overview about the problematic in the region, because we have a lot of problem with the destructive situation with big companies in our region, and particularly in Ecuador. En ese sentido, el arbitraje internacional, digamos que en la región y Ecuador en particular, hemos tenido un inconveniente, digamos, serio, porque los países no democráticos, que no han tenido gobiernos democráticos, han desarrollado una posición contraria al arbitraje internacional. Es un primer factor importante que hemos tenido como un choque frente al desarrollo del arbitraje internacional dentro de la solución de controversias para temas de cambio climático. Eso que implica el hecho de que países como Ecuador, hasta hace 2 años y medio atrás, no contábamos con la posibilidad de introducir en los contratos en petróleo, en gas y en minería, oro, cobre, lo que fuese, la posibilidad de entablar una demanda arbitral porque no había cláusula arbitral. Esto genera un problema serio porque justamente trastoca los principios del arbitraje internacional, que el no involucramiento de factores políticos y decisiones políticas dentro de las relaciones comerciales con los estados y las empresas, ¿no? Las partes privadas. En esa lógica, hoy por hoy, en el caso de Ecuador y algunos países de la región han retomado el arbitraje internacional, justamente acatando los tratados de inversión bilateral con diferentes países, justamente para dar certeza a esas inversiones, porque evidentemente son inversiones de montos muy importantes, ¿no? ¿Qué implica eso en la práctica? Que tenemos ahora un reforzamiento en la invitación a poder invertir en temas de energía, en temas de minería, en temas de petróleo, y al mismo tiempo una contradicción con la necesidad de introducir políticas para proteger el cambio climático. ¿Qué es lo que ha pasado en la práctica en la región, particularmente en Ecuador, sobre todo en la parte judicial, porque arbitraje internacional no ha habido mucho? Es justamente que la posición del Estado ha sido la de ser demandado por temas relacionados a cambios en el ecosistema cuando se han desarrollado proyectos mineros y proyectos petroleros. Entonces, eso de algún modo, digamos que ha empezado a generar un conflicto porque los estados están ahorita en la dicotomía, en la disyuntiva de qué aplicar. Si aplicar digamos, el compromiso y la seguridad jurídica que debe tener un contrato en temas extractivistas o hacer un tema más relacionado a flexibilizar cláusulas dentro del contrato para efectos de lograr reducir la probabilidad de demandas frente al Estado por incumplimiento contractual. Por ejemplo, un caso que es muy riesgoso en Ecuador es todo relacionado con la consulta previa en temas mineros. Entonces, tú explotas el oro, explotas la plata, explotas el cobre en nuestro país y eso tiene un contrato, ¿no? Por lo general, la relación es a través de concesiones. Tú permites que el Estado te autorice la posibilidad de extraer recursos mineros, pero el momento en que tú explotas estos recursos, tienes evidentemente una incidencia en el ecosistema y son sectores muy vulnerables. Pasa lo mismo con Colombia, pasa lo mismo con Perú, con Brasil, con Argentina, con Bolivia en el tema de litio. Y entonces hay una figura de la consulta previa, que es una figura que se introduce en la Constitución y en la ley, que es un tema también regional, que lo que busca es que la comunidad que vive, que se asienta en esos espacios donde va a explotarse los recursos metálicos, puedan decidir si quieren o no que ese proyecto minero entre, ¿no? O ese proyecto petrolero, ¿no? Extractivista. Y ahí viene otra vez el conflicto entre el tema del medio ambiente, el desarrollo de políticas en pro del medio ambiente y el desarrollo económico de los países que tienen esos recursos para poder desarrollarse económicamente y poder desarrollar otros sectores sostenibles, ¿no? A la larga, la lógica de la política pública en inversión es esa. Afecto el medio ecosistema temporalmente para poder desarrollar otros proyectos en el futuro que sean sostenibles, ¿no? En temas de agroindustria, turismo, temas relacionados con desarrollos financieros y bursátiles, etcétera. Es decir, buscar sectores menos digamos, agresivos, ¿no? Sin embargo, esto lo que ha generado es que los contratos sean, porque hay contratos anteriores, son contratos ya firmados con empresas multinacionales, igual que Mapfre, multinacionales en el ámbito minero, canadienses, australianas o chinas, o en el ámbito petrolero, norteamericanas, españolas, italianas. Y el problema es que esos contratos están vigentes ahora. E introducir y tratar de hacer cambios de esos contratos es complejo porque evidentemente las empresas no quieren ceder un espacio peligroso, ¿no? De ahí que la lógica de arbitraje internacional se plantea, en inversión básicamente, se plantea con los nuevos contratos. Es decir, los nuevos contratos sí están dejando abierta la posibilidad de que los estados puedan introducir cláusulas que minimicen el compromiso y el riesgo de ser demandados por las empresas extractivistas. Pasó ya en un caso en 2019 en Holanda, en los Países Bajos, justamente una empresa alemana demandó por 1.4 billones de dólares al Estado holandés, a los Países Bajos, justamente por no haber cumplido, por haberse visto afectado a futuro, porque son contratos de 25 o 30 años de plazo, verse afectados en el cumplimiento, en el posible cumplimiento de sus ofertas, ¿no? Para que puedan extraer el petróleo o los minerales. Entonces, de algún modo, esto ha generado un problema serio, comercial, de inversión, porque la ciudadanía, la población están asentadas en el sector.
Just sorry for
Sí.
1 minute more,
Perfecto.
because also
Sí.
we're missing audience.
Está bien.
Okay.
Entonces, el problema que existe es que tenemos dos actores, la sociedad civil organizada, que quiere demandar al Estado por permitir que se siga explotando y afectando el ecosistema propio, el Estado que debe cumplir sus contratos de inversión y adicionalmente cláusulas rígidas en los contratos actuales que están vigentes y la flexibilización de cláusulas que permita al Estado, eventualmente cambiando de política pública en temas medioambientales, poder lograr equilibrar y permitir que haya un arbitraje mucho más sensato entre ambas partes. Entonces, digamos que ahí está el conflicto que yo veo entre Estado, inversionista y sociedad civil, ¿no?
Well, thank you very much. Again, apologies for those who didn't understand, but we're going to turn again to English, and I want to hear a lot of what José Antonio has to say. He has a lot of experience in investment arbitration, and I think this topic that he's going to speak about is very interesting. I myself am not that much aware of it, so I'm all ears to hear about what you're going to say. And it seems that there is a part of the doctrine that questions whether investment arbitration is a dispute resolution system that, you know, may help mitigate climate change disputes. So my question to you is whether you think that investment arbitration is inherently a dispute resolution mechanism that prevents states from having a responsible approach to climate change and to the protection of the environment.
Thank you, Pilar. Just to summarize, no. No, but let me share with you a little bit where I'm coming from. I mean, I think that it may be relevant to say that in previous parts of my experience, I have had the honor or chance to serve as counsel for states in cases related, in investor-state arbitration cases related to environmentally relevant projects. One related to an environmental park where an investor wanted to build another Disney World, and that didn't happen. I've also been involved in cases related to mining and environmental impact, and on investor-state arbitration, I have also been part of ICSID as counsel about 20 years ago or so, and I teach investor arbitration and public international law and ICJ judgments at Georgetown. So that's sort of the background for everyone's knowledge. Now, in terms of addressing Pilar's question as to whether investor-state arbitration is by nature or inherently a system that is not really built for or to address responsibly climate change issues and investment issues and environmental issues? My short answer is no, but let's see how I get to that conclusion. So the roadmap that I would like to share with you is the following. First, share with you some statistics in terms of environmentally related cases. Second, refer to some of the cases that involve climate change or environmental aspects, where I believe that there is a mix, and unfortunately, the appearance is that everything is against the state, which I don't think statistically or in reality is the case. And finally, try to dismount a number of myths that exist there, and if I get there, and then Pilar allows me, get to two conclusions. But so let's do this fast.
I
So
will.
in terms of statistics, based on 2022 statistics from UNCTAD, just be mindful that of two aspects of those UNCTAD statistics. One, only 38% out of 175 environmental ISDS cases analyzed by UNCTAD were decided in favor of the investor. The remaining cases have been either won by or not lost by the state, or they have been discontinued or settled, etc. So the statistics doesn't support the notion that ISDS is a failure to environmentally related cases. Now, moving along, most of the cases have that have been relied upon for these cases. Most of the treaties that have been relied upon for these cases refer to cases signed in the 1990s. So that at least borrows the notion that after the 2000s there have been more modern treaties that may have helped as a sort of oxygen chamber for environmentally related issues. Now, let's talk about the cases where my contention is that yes, there have been cases where tribunals have been or have had very little awareness of the importance of climate change and the environment. And to name a few, one can think about Occidental versus Ecuador. One can think about cases such as that one. You can also think about the case of Ecuador versus Colombia, where on the one hand, and this is positive. On the one hand, the tribunal said, yes, the annex on indirect expropriation has an exception, and that exception allowed the state not to be called on liability for expropriation. There was no finding of expropriation because the tribunal recognized that there were police powers, and there's an exception at the end of that annex, indicating that for certain measures based on legitimate purposes, you can actually take environmentally related measures. So that's on the positive. On the not so positive side, on fair and equitable treatment, there is a general exception that was absolutely not read by the tribunal, and it's a general exception. There was no interpretation as to give the exception any effect, going against the notion of effet utile, and that in itself is problematic, because if you have an exception and you don't use it, why is it there? So that's on those cases. But then we have to look into other types of cases that have also been in investor arbitration, such as Perenco, where yes, there was liability against Ecuador on the one side, but this was, thinking a little bit about what Ximena shared, one of the few cases in investor arbitration where the tribunal actually appointed an expert to assess the environmental damage caused to Ecuador, to the Amazon, caused to Ecuador by the investor. And there was, it is one of the few counterclaims that has been successful in investor-state arbitration history. And this is very important because you start to see in tribunals being mindful of this. Yes, there was sort of a compensation by liability for Ecuador, or against Ecuador, liability against the company. So those are cases that are important, and let's not forget all the renewable energies cases. We have had about 80 cases, and without dealing into European law, because I believe that and
50 of those cases are Spanish cases, actually.
My
so-
European friends here will forgive me for what I'm going to say. I think that European law is very important, but at the same time, it's not super international law. It's international law is international law.
It's regional,
and-
international.
And it's above even regional international law and domestic law. So in that sense, we have more than 80 cases in which the claimants brought cases for investments that were allegedly made into renewables. And that is significant. Whether or not they were upstream financial investors, whether or not they were making themselves the wind and solar, it's not really relevant. The part is they were investors, and the system itself proves that those investors are also able to make claims themselves. So that's the mix of cases. Now, into a couple of myths that may be out there. There's one that the system is not really prepared to give space for special rules on investor state on climate change, and I call it a myth because you see that there are being various treaties. Think about the how are we doing on that? On time?
I'm more mindful that Lisa has a class at 12, but it's not your problem. It's not your fault.
Okay.
You're
So just give me one.
you're right on
2
time,
minutes. Okay.
and
Okay.
I allow the other panelists to
Okay.
speak more. But I'm
Just give me two
we're-
minutes and I'll wrap up. So in terms of the myths, I want to point out that there are various treaties that come from the 2000s that provide clauses that allow, for instance, exceptions. In the indirect expropriation was one exception. You have treaties that are very avant-garde in the sense that they have binding environmental assessment obligations for investors, like the Nigeria-Morocco bilateral investment treaty. You have the Colombia Canada FTA, which has ESG and corporate social responsibilities. Yes, soft law obligations.
The Colombia Spanish BIT has
the Colombia Spanish BIT, which is even more modern than that, but still with soft law obligations.
correct.
And you have a set of rules that provide a different perspective. You have rules indicating that there is no obligation by the investors by the state, to relax the environmental rules, which is very important. So my sense is when we talk about special rules in arbitration, well, the special rules in investor state arbitration are the newest treaties. Unfortunately, when you sign a new treaty, you're not necessarily undoing the very old treaties. They stay out there, which is a systemic problem, but there may be ways to handle it. Now, we can in the conversation we might be able to talk about additional myths that are out there. But I want to conclude this by saying two things. Where do we go from here, or what is the next step to recognizing that the system of investor arbitration is not inherently evil. The idea is to modify the system with treaty making, because what is the system? Who created the system? Sovereign states.
Correct.
Nobody else. So the same states that are claiming regulatory power are the ones that have the power to modify the treaties. There is treaty negotiation power. I myself was a negotiator for Colombia for more than 4 years. The state has a sovereign right to modify the treaties, and that is possible. How can that be? I'm very attentive to ancestral negotiations, which are mainly procedural. But my sense is that for there to be a more balanced system, there's one element lacking in the whole system, which is you look into the BIT or the investment treaty. You look into the whole pages, and almost 95% of the treaties have no obligations for investors.
Correct. Yeah.
And that would be the next step. And it's coming. Obligations on climate assessment and climate change assessment, environmental assessments, community consultations, which is not very easy, and obligations in terms of other ESG-related obligations. How deep should they be? My position is they should only get up to what may be customary environmental and labor-related obligations, because if you make them too detailed, then you're overly regulating something that the states have the right to regulate themselves. So that should be sort of the standard. And then I would stop here.
We can continue after Lisa's gone. Yes. I apologize because you have to wrap up.
Yes,
But
it'll be good news that you can continue after, because
we are very...
Can I have 5 minutes? Because then I have to run.
Of course, okay? Yeah. I will not even ask the question. So.
Yeah, well, I have plenty to respond to. I can't do it justice in 6 minutes, but I'm so sorry, but I am teaching at Colombia at 12, so really do have to run. So maybe just a few responses. First of all, there is a gulf of a difference between commercial and investment arbitration. And so I've learned a ton on commercial arbitration, but in reality, this should be two different discussions, because the extent to which, business in inter-business relationships, climate change should be, resolved in disputes is a very different question from the ability of states to challenge government measures that are taken advancing climate change. So that's my specialty. My specialty is investor-state dispute settlement, and I think it is absolutely, it is really incompatible with the energy transition and with the substantial transformations that are necessary that you started off our whole session with, that we need deep structural transformations in all countries, transforming energy sectors, transforming all sorts of sectors. This is going to require substantial government regulation that really restructure their economies. And investor-state dispute settlement fundamentally thwarts government's ability to do that. It is a mechanism that allows investors to challenge governments for any measures that governments take that undermine their economic viability. That's going to be a lot of investment, a lot of measures. So it's nothing that I can do justice to in 5 minutes, but just to say structurally it's completely different from commercial arbitration. Yep. I would look at actually let me quickly myth bust the myth busting, because I think that we should take caution when thinking about some of the things that you laid out. I think kind of the least useful, but let me just respond to the point on statistics and how many cases states are. Hard to have a conversation rushed and interrupted, but just in terms of the statistics, just to be mindful of it, the statistics of how many claims states won versus investors is very hard to read. First of all, a lot of the cases that states win are actually jurisdiction. When you look at the cases won on the merits, it's mostly won by states, and that doesn't include cases that are settled, which we've looked at. Cases that are settled, they are wins for the investor. They may not be, the scale, but they are wins for the investor because they are concessions on behalf of the state. And what they certainly don't include are all of the cases that are all of the measures that were challenged because of a threat of arbitration or because of the informal threat of arbitration or because of the specter of arbitration that has caused states to not take the measures they would have taken or to roll back arbitration. And by the way, that regulatory chill, which is very hard to document, is becoming more and more visible. We have Norway and Denmark and New Zealand that said we are not taking actions that we need to take for climate because of fear of being sued. So that's important. Just when looking at the statistics, I don't find it as helpful to say who's winning or losing because there's a lot that's under the surface. That's one thing. The second thing is that the 80 cases that challenge regulations in the renewable sector, I see as thwarting climate change, not in favor of climate change, because what they are challenging are states' abilities to create and modify their regulatory framework that is consistent with the energy transition.
Correct.
Good investment, good incentive policy requires that states adjust their incentive schemes and adjust their regulatory framework in light of the evolving technology, market conditions, economic needs, and other social and governance concerns. States need the flexibility. That is good incentive policy.
Yep.
So any stabilization imposed on states is inherently contradictory to the regulatory powers that states need. I think the final thing I would say, even though I have so much that I would like to say, but the final thing that I would say is that with where I come from is we have an existential challenge to avoid a climate catastrophe. And by the way, that is embedded in a broader existential challenge of achieving sustainable development, because climate change is a massive crisis, but it is frankly one of our many massive crises, including poverty, other environmental crises, and so on. Investment is critical for realizing those sustainable development goals. We need trillions of dollars of investment to achieve the energy transition. Much of that investment is going to be international. So where I come from is, what should an international governance framework look like, including a dispute settlement mechanism that will help to advance those goals? The presumption of investment treaties is that these treaties, by providing legal protections that are enforceable in ISDS, will help to advance investment. That's the presumption on which they stand. And as I go around the world saying, I wrote a book on this 15 years ago, 15 years ago, more, looking at the evidence of whether these investment treaties have actually helped to facilitate investment. And 15 years ago, there were already dozens of empirical studies that failed to show any effect on investment flows. There have now been even more empirical studies and meta-studies of empirical studies, the most recent of which that I know of is from 2021. There was a study of an empirical study, there was a meta-study of 74 empirical studies that said that the effect of investment treaties on investment flows is negligible. So we have this entire system, 3,000 treaties, built on a false assumption that that's what's needed to advance investment. We have a real need to advance investment. So what I look at is, what should we actually do? What should an international investment framework looks like that would actually help to advance the investment that's needed? We wrote a report on this last year, because in the energy sector in particular, what's really needed are energy roadmaps, clarity for the energy sector, offtake agreements, access to low-cost finance, all sorts of things that can and should be addressed at an international level, and that so far are not. So the way that I see the investment regime is a regime that is built on a now debunked presumption that these treaties are effective, necessary, or even effective at mobilizing investment. They're not. They're thwarting government's ability to take really important action. To me, this is not about, by the way, there was a comment, I think, in commercial arbitration that communities and affected stakeholders can participate in most investment disputes. Out of the 1,000, there is no participation of anyone other than the state and the investor. Sometimes communities or others try to participate. We tried to participate in the Bear Creek dispute against Peru, and the tribunal said, no, thank you, your views are not relevant. So it's actually extremely hard to have those views heard. A lot of entrenched interest in the system. So what I would advocate for in terms of the way forward is a fundamental rethink, not a tweaking of the procedural rules, not I would start from the question of, what are we trying to achieve? We are really trying to accelerate investment. We are trying to do so in a way that is supportive for the investments needed. That means the investor, I'm not anti-investment, to the contrary, we absolutely need the investment. So what do investors need and want, and how can we achieve that in an international investment framework?
Well, thank you, Lisa. That's a very interesting topic. I think you touch upon a few things that are pretty relevant today, which is, I guess, you're addressing the imbalance or the asymmetry in investment arbitration, right? And I think the more, touching upon what José Antonio was saying, the more states and policymakers are evolving towards implementing or including these changes in the BITs and the multilateral investment treaties by allowing states to have more regulatory power this imbalance can be rebalanced a little bit?
Can I say one thing?
Yes, go, please.
So the modern treaties are not resolving the problem
No,
for a
I
couple
agree.
of reasons. There's a great book on this by Wolfgang Alschner, who the book is called something like New Treaties, Old Problems, or something, Old Outcomes, or something like that. And he shows that these modifications, these new treaties, are not resulting in different outcomes.
Into
And
actual
there-
results.
Right, and there are many reasons for that. First of all, the bulk of cases continues to be brought under the 2,800 old treaties or whatever. So, as you said, I mean, I think you said these are not replacing necessarily old treaties. And in any event, there's so much treaty shopping and so much ability to continue to bring claims under old treaties, even when claims are brought under new treaties like the Echo case and others that have some of these modern provisions. The modern provisions are not resulting in changed outcomes, and Wolfgang Alschner talks about many reasons why that is, including that arbitrators are still reading into these clauses kind of the more traditional interpretations. I don't think that putting an investor obligation, I'm not in favor of putting in investor obligations, because that doesn't address the fundamental point, which is that what are these treaties accomplishing? I mean, there are many, so I don't think the point is to rebalance between investors and states. I think the point is to think about what should an investment framework look like that is conducive for all and that is helping to achieve the needs of all. The closest I've seen to that is Brazil's treaties, because Brazil asked their investors, their outward investors, what do you need, what do you want in an investment treaty? And what they want is facilitated access to, like import arrangements and visa situations, and what is like really practically of concern, and how should disputes be resolved? They have intergovernmental committees and an ombudsman and other means of resolving. So that's a quite different model that I think approximates closer to what a facilitation agreement, as they call it, might look like.
So let's say the imbalance is been tried to be resolved, but not in the right way, in your view. But in my view, if I may, at least we're trying, and it's the beginning of the change. If that makes sense. And the other thing I think it's interesting, which is what we're talking about the amicus curiae, is precisely following up on what we're discussing about the changes of the arbitration rules. I think is that yes, third parties are being, in some cases, allowed to speak, but their words are not being taken into consideration by the tribunals when decided. So in the end, it looks very pretty, looks very good to allow them to speak, but at the end of the day, it doesn't have any practical use. That's where I think I was referring to the Colomés Gold case, which in the tribunal decided in a way in favor of the community, of the indigenous community, but not because of what they said or they mentioned in their participation. And I think that's where part of the change is needed, right? You have a lot to say, and we're sorry for putting you in the end. I'd like to continue this conversation.
Yeah.
Feel free to leave when you have to.
Sorry that I do.
But we'll continue with the other panelists, and thank you for joining.
Let me share just two comments very briefly. One, the notion that dismounting the whole investor-state arbitration system would be a solution is to me extremely concerning, in the sense that or in your example, moving from the investor-state arbitration system into the Brazil model or dispute resolution system is akin to saying we're moving from a rule-based approach into a more diplomatic-based approach, and that in itself is going backwards, perhaps 40 or 50 years, in the sense that the disputes would be resolved by what state has the biggest, the biggest strength in the geopolitical scene, which is extremely concerning. Think in terms of, would we want that for state-to-state cases? And I mean, this is recorded, so don't worry. You'll be able to see it. Yeah.
Also, the next panel starts right now, so I think we